Let's look at joint account. Joint account. Any account consisting of two or more related or unrelated parties. Mandate or account signing conditions. How the account will be operated. Account opening. Establish the identities of the individuals who open the account. Next, you have to obtain the mandate as how the signing condition is. Is it one person sign to withdraw the money, or two? You need two persons to sign, or either one. Also look at the party involved. Who are authorized to operate the account? The account signing condition. State the account for opening the condition for operating the account. One of the main thing is issuing checks. Is it anyone or either one? Both to sign or all to sign? It all depends on how complex is the requirements, are the requirements. All parties have to give consent on the giving of a power of attorney to an outside party. Joint and several liabilities. Debtors are jointly and severally liable for the debts. Banks can bring more than one legal action against debtors if it is not satisfied with the first action. Individual account can be used to offset against the joint debt. So the standard clause, joint and several liability in the bank terms and condition. In short, we call T&C. Next, we look at situation concerning the death of joint account holder. If there's a credit balance, the common law rule of survivorship applies. It means the remaining credit balance is passed on to the survivors. The deceased representative can look to the survivors for his or her shares. If the survivorship clause is not incorporated in the account opening form, contrary intention is discernible. Balance may not be passed on to the survivors. If it's a debit balance, the account should be stopped immediately. The whole code will be placed on the account. Checks, how about the checks presented? Checks drawn by the deceased after the date of passing are to be returned, rejected and returned. Checks drawn by survivors are good for payment. Checks presented. Banks will place a whole quote on the account. This will request the survivors to open a new account. There will be grace period for the account holder, the survivors, to close the account, to close the existing account. Okay, allows the existing account to sort out whatever things that anyone need to before they close the account. Okay, next we look at bankruptcy of a joint account. If there's a credit balance, the account should be stopped immediately. Checks drawn by bankrupt are dishonored and marked bankruptcy petition presented. So checks drawn by other parties to the accounts are returned, and marked joint account holder X. This is basically involved in bankruptcy proceedings. The credit balance here is that new accounts opened for remaining solvent parties be operated jointly by the party and official assignee. the credit balance here is that opening of a deposit account by a bankrupt requires approval from official signee. So it's operated jointly by a receiver appointed by court and remaining sane parties. Usually a new account will be opened. If there's a dispute among the holders, joint signature accounts. For joint signature accounts, if the signing condition is all to sign, it means basically all the parties have to sign, all the account holders have to sign. You need consent of all the parties to change the mandate, okay, or to withdraw money. So if in case any situation you want to make changes, all have to sign, especially then when there's a dispute among the account holders, even more for drawing out money. For joint and alternate signing signature accounts, so basically if the signing condition is either one or and all, each party has equal right to access account and transact. However, consents are still required from all account holders, okay, for any amendments or account closure. When it comes to amendments or account closure, you still need all the parties to sign, to consent to it.